Now, I can't do an equal pay talk without talking about the Dagenham Ford sewing machinists. It's 50 years since their strike, and it's become almost the most famous strike in history. And it produced headlines like this: "Made in Dagenham, a 1968 strike led to equal pay for women." Now, this begs a whole number of questions. And the question is, is that true or false? First question, did they get equal pay? And the answer to that question is sadly, no, they didn't. The dispute at Ford arose because Ford had introduced a new job evaluation study immediately before this, and the women who made seat covers were graded grade B, and they believed that they were skilled workers and they should be graded C. And not only did they not get C, they actually didn't get B either. They actually only got paid 85% of the grade for B because they were women. And they went on strike. So if you go back to this photograph, you'll see that it doesn't mention equal pay in their placards. Their dispute was that their work was not being properly recognised. And so they raised a grievance because they said that they should have been grade C on the new job evaluation scheme. So they lodged a grievance with their employers. Their employers rejected their grievance. And instead, this is where their action becomes really interesting. Instead of going through the activities of the trade union, they organised amongst themselves and walked off the premises. No balloting in 1968, no rules to comply with, they simply walked out altogether. And then they were followed by their sisters in the Halewood strike in Liverpool, which often doesn't get mentioned. What happened then was that Barbara Castle intervened, and she came along, met the women, and she set up an external inquiry into their complaint. This was called the Scamp report, and one of the side notes is this is a three-person panel, the Scamp report. One of them was a Miss Anne Shaw, and the Daily Express reported that she was one of only 2% of women who earned more than £5,000 a year. That is equivalent to £150,000 a year now, which 12% of women meet, so some progress. The Scamp report took 3 months to report and spent most of its time arguing the fact that they had not gone through the relevant procedures and rejected the women's complaint. The women were then offered phased rate B. And so over 2 years, they got the B rate, but they were rejected and the C rate. What happened next was the Equal Pay Act was passed. It didn't apply to the women in Dagenham. They were unable to use the legislation. It wasn't until 1984, when the legislation was changed, that they were able to challenge the job evaluation scheme. So in 1984, they submitted a claim to the Employment Tribunal. The Employment Tribunal rejected their case. So they had to go on strike again in 1984, and that was a second external inquiry. So only at that point did the women of Dagenham actually get the grade C rate. And then 6 years later, Ford moved production of seat covers to Thailand. So the question I want to pose to people is, why is it that a strike that involved only 187 women lasted only 3 weeks and was, in its own terms, completely unsuccessful, has gone down in history as one of the most iconic strikes that's ever taken place. These women now get invited on the red carpet. They were all at BAFTAs for the Made in Dagenham film. I've been at various presentations where the Labour Party has lauded their conduct, but they lost. Second question that arises is, did they cause other women to get equal pay? This is a more complicated question, but in my view, the answer to that is actually also no. The fight for equal pay goes right back to the Treaty of Versailles in 1919. It actually, Principle 7 of Article 427 of the Treaty of Versailles says the principle that men and women should receive equal remuneration for work of equal value. So there's been a national, and we signed up, obviously, to the Treaty of Versailles. The Treaty of Versailles created the International Labour Organization, and we are signatories to the International Labour Organization. So UK has had a commitment to implement this since 1919. And even more significantly, the Dean having stolen half my lecture, is the Treaty of Rome. The Treaty of Rome was passed in 1957. It was to become a cornerstone of equal pay, indeed many discrimination legislation. And it does indeed include the obligation for equal pay without discrimination based on sex. Now, why this is crucial is because Barbara Castle, and Barbara Castle is a legend of equal pay. I chose this particular photograph because I think it sums up Barbara's approach to these issues quite well. Barbara is clearly, and we'll see in a second, fully committed to equal pay for many years. This photograph has become an iconic photograph. If you look up Google and put in Ford sewing machine disputes, this photograph comes up almost every single time. But in fact, it had nothing to do with Dagenham. It's in 1954. This is Barbara campaigning for equal pay many, many years before the Ford Dagenham dispute. And indeed, she managed to get a commitment to equal pay in both the 1955 and 1966 manifestos. And the thing about Barbara Castle was her fight was not to get equal pay. Her fight was constantly to get over the hurdles that her own colleagues in the cabinet were creating at that time. So there was a vague promise. The reason that sewing machines was significant was because it was helpful to her in her campaign, but as her campaign that existed beforehand. I've been going through Barbara Castle's diaries in relation to this matter, and I'm sorry I'm going to bore you, but I do want to read out this passage. This is from October 1968, so this is actually 4 months after the Dagenham strike had taken place, and indeed 4 months after they had already gone back to work. At this point, amongst the many strikes that were taking place at this time, there was a complete threat of strike action in the engineering industry. At that time, collective bargaining was industry-wide. It wasn't employer-specific. And the employers were disputing the pay for 1968-69, and Barbara Castle became involved in the dispute. And she said, "I was still brooding over my anxieties when Douglas came to say the unions had asked me to see me about the question of equal pay. The employers had agreed to a £19 skilled rate for men in 3 years' time, with £13 for the women. The unions had accepted the former, rejected the latter, now asking to see me most unreasonably. I exploded at this, telling Heron tartly that I had been warning everybody about this all along. So I was in pretty savage mood when Hughie, Les Keeley and others, including Marion Veach, the only woman on their team, came in. Hughie told me unctuously that everything had perfectly well until the employers had come to the women's rate. The increase they offered here would have actually widened the differential and was quite unacceptable. The unions wanted the women brought up to the labourers' rate of £15 in 3 years' time as a minimum. Otherwise, they would break. I was furious with the employers for having allowed themselves to be manoeuvred into this trap, particularly as I know that none of the unions really expected the women to get the labourers' rate. Indeed, I had in my possession a note we had got privately from Les on what he thought would be a satisfactory basis for settlement, in which he included a figure of £13.16 for women at the end of 3 years. Of course, it's part of the whole conciliation code not to disclose this. I blew my top, telling them that icily that I'd been waiting a long time to hear what they were going to start talking about, the women, and was shocked to find they'd left it to the very end. They knew the employers only had a limited amount of money to offer, and it wasn't my fault that the unions had preempted it all by pushing up the skilled rate. So, 1968, we've already had the Ford strike, and the unions are going in directly negotiating for a lower rate for women. So, oops, go back. This is another quote from Barbara's diaries, and it's a bit later when they're actually doing the act. In trying to make my bill as watertight as possible, I was faced with two definitions of equal pay. The first was the ILO definition, equal pay for work of equal value, and the second the EEC formula of equal pay for the same work. The former struck me as too vague and the latter too restrictive. The ILO definition did not indicate how value should be measured or enforced, while the EEC phrase, the same work, was clearly inadequate. So it's quite clear that Barbara Castle was well aware of these choices that needed to be made outside of the dispute involving the sewing machinists. So in reality, although it was a publicity and a persuasive tool for her, it wasn't the cause of the Equal Pay Act. The Labour Party and Barbara Castle knew that they had to comply with Europe in due course, and they were well aware of the relevant international obligations. So we're still left with this question. Why is it that Dagenham has become such an iconic position? Why is the myth still living on? So next issue, the Equal Pay Act itself. What's wrong with the Equal Pay Act 1970? What's right with it is almost a better question. So this is some legal... It only included like work and work rated as equivalent. This meant that there was no right to equal pay for work of equal value, no right to challenge a job evaluation scheme. This was why the four Dagenham women were left high and dry, because they were actually bound by a job evaluation scheme. They had no way of actually challenging it. This is actually still a major issue. Challenging job evaluation schemes is part of the litigation that I've now been involved with for 30 years. And it is really unpopular. I was involved in a dispute in Sunderland, and we won the first round of equal pay cases, and then we had to go. And then the employers changed the job evaluation scheme, and miraculously, the result of their new job evaluation scheme was that men were still getting paid significantly more than the women for the same jobs that they previously accepted was discriminatory. So we challenged the application of the job evaluation scheme in Sunderland. The result of that was that the local MP, Labour MP, Chris Mullen, organised a parliamentary debate to slag me off for raising the question or challenging a trade union dispute. Now, what actually happened was we then had to spend 100 days in tribunal, the second longest tribunal ever, and we proved that the second scheme discriminated against the women. And the women won £20 million in back pay. Chris Mullin has never apologised to me, not a surprise. What was worse, actually, was I didn't even know the debate was going to happen. Not a single one of the local MPs, many of whom I knew, ever contacted me prior to speaking in a debate to find out why it was that we were challenging that scheme. This pattern is still going on. The Glasgow litigation, which we'll see later, the Birmingham litigation, all involved exactly the same issue, being able to challenge the schemes that employers introduced. Maximum claim for 2 years. This one's often forgotten. Even if a woman was able to establish that she was being discriminated against and was receiving less pay than a man, doesn't matter how long that discrimination had been taking place, the maximum that you could get under the original Act was only 2 years from the date that you put in your tribunal claim. This, from my perspective as a litigation lawyer, was a huge impediment to pursuing cases, because the amount that you would receive at the end of the day was often significantly less than the amount it would cost you to pursue the cases. But there was no challenge. Nobody raised an eyelid about this at the time. It excluded pensions. I don't know why that was done, but it was a huge hole. It remains a huge hole in the Act. And I want to come back to pensions in a second, because it's so important. There was no definition of the material factor defence. Litigation, case after case after case, was involved fighting over how we interpret that particular provision, because the definition was so loose. It was a pure contract jurisdiction, not tort. And as the Dean was saying, the Equal Pay Act is probably the second possible discrimination legislation. But the body of legislation that we have now is founded on tort. And it enables the courts to have a far wider degree of redress to those that are involved. It remains the bizarre position that if an employer discriminates in pay on the grounds of gender, all you can get is your back pay. If they discriminated in pay in respect of any other protected characteristic, they would be able to get injury to feelings, exemplary damages, other remedies that go with the discrimination legislation. Only women, and it's obviously 90% of the claims are related to women, only in respect of gender-based discrimination does that exclusion still exist. We have challenged this and lost in the employment of tribunal. We are still having to pursue that issue, and we may still, if we get a chance, we may actually have to seek a reference in respect to that issue. But it's only because the original legislation was founded on this contract basis. And then we have the 5-year plus. As the Dean said, the Act came into force in 1975, but it was the 29th of December 1975. So I always think of it as 1976, because the chances of anybody putting in a claim over the New Year holiday was pretty remote. It gave a period of adjustment, which was never in fact used by most employers. And when we were fighting the litigation in the North East 30 years later, the big complaint was employers need a period of grace. And I was thinking, but they've already had a 6-year period of grace way back in the 1970s. The most significant part of that, of course, is that 5 years took place between 1970 and 1976, and we joined the EEC in 1973. And that will come back to in a second as well. I just want to deal with the question of pension injustice because it gets missed off so much, and you get so much focus on the GPG stats for working women. But the pension injustice is something that lasts for the whole of people's life. So when people say it costs a woman $150,000 over their career, they forget that there's another 20 years after their career where that discrimination actually continues. Because it's not in the Act, people just forget it. Time and time again over the last 30 years, I've had to try and fight to get employers to pension or make their awards pensionable. In Scotland, we had to go all the way to the First Minister to get a local authority to agree to make their equal pay settlement pensionable. We were the only, that's my firm and my colleagues, were the only people who were pursuing this issue of pensionability. The trade unions wrote it off as a significant issue. So outside of the Equal Pay Act, the consequences of the discrimination in pay has a lifetime effect. Even the new state pension, 90% of men get the full rate, only 40% of women get the full rate. In defined contribution schemes, women only save half the amount of money as men. And the average pension pot for women aged 65 is only a fifth of the average pension pot of men. And this is the saddest statistic and causes me grief on an almost daily basis. My clients generally earn about the poverty level, 60% of our average wages. They cannot afford to pay their pension contributions. 6% of £20,000 is £1,200. £1,200 on someone earning that level of money is huge. And I spend, so when I was doing the Birmingham cases, I literally had to ring up every single one of my clients to try and persuade them to make their awards pensionable, because they almost all automatically opted out. They'd rather have more money in their hand now than think about the long-term consequences. And they were huge. Well, I had one woman who was asked to pay back contributions of £5,000. I had to ring her up and beg her to enable us to pay that money. She agreed. 6 weeks later, she got a cheque for £34,000 in back pension and an increase in her pension of £15,000. That £5,000 turned into over £200,000 for her. But it took forever to be able to persuade her that that was going to be the consequences, because she was worried about having to pay that. So if you haven't even got a settlement and you're making those decisions in advance, women are suffering as a result of this position. So the effect of the Act, the Equal Pay Act, was one thing was absolutely pretty much immediate, and it's a good thing. These men's rates versus women's rates almost disappeared overnight, and that was a good thing. But fighting equal pay cases was not something that happened. So these are the ACAS statistics of the number of equal pay cases submitted immediately after the Act. 701 going to tribunal in 1976, 576 in 1977, 284 in 1978, 200 in 1979, by 1980, 63. That's 63 cases in the entire UK. So there was a big effect immediately, and then it all petered out. So one thing, as I said, myths have consequences. The Labour Party convinced itself that it had produced the best act possible, and it was not going to be persuaded that actually it had made a mistake. So when we joined the European community, they refused to amend the Act. The government had to be taken to the ECJ by the Commission because the party refused to accept that actually the Equal Pay Act did not comply with its EC obligations. And the only reason it did that was because it believed, and it maintained that position that the Equal Pay Act was good enough in case after case, all the way up till the year 2000. They were still arguing the same thing. So the consequence has been that since 1970, unless forced by Europe, there have been no significant legislative changes in respect of equal pay since 1970. And the Brexit myth. This is a really weird one. Part of the Brexiteers' argument is we would be better off outside Europe is the Equal Pay Act. I have Twitter spats with Brexiteers telling me that we don't need to worry about employment law because we had the Equal Pay Act in 1970. And therefore that's proof that we didn't need Europe. Bizarre, but that's the position. So this is my next legend, the EU. There is absolutely no doubt that without the EU, we would not have an effective Equal Pay Act. With all the problems that it still has, it would be a hell of a lot worse if we did not have the EU. So, legend, an EU legend, Gabrielle Dufresne. She's definitely a feisty fighter, Gabrielle. She fought her case against her employers, the airline, for over 10 years. She went to the European Court of Justice on 3 occasions, which I think is a record for a single case. But her second case, she actually lost 2 of them, but the second one is one of the most important EU cases of all time, because it established the right that the Treaty of Rome was directly effective for all EU citizens, not just for public sector employers. That then led to the principles of horizontal and vertical enforcement. We are still using the rules that Gabrielle created for us. Second legend, British legend, is Professor Pam Enderby. Pam was a speech therapist, and she was the lead claimant in what was, I think, the second largest Equal Pay Act claim prior to 2002. They were comparing themselves with clinical psychologists and pharmacists. And as with many equal pay claims, there was gender segregation in the NHS. The vast majority of speech therapists are female, the vast majority of clinical psychologists and pharmacists were men. So she launched a claim in the courts. She lost in every one of the courts in the UK, and took the claim to Europe, and she established 2 very significant principles. The first was the right to compare across collective bargaining arrangements. The employer's defence was that they had different unions representing each of the professions, and they could not prove an intent to discriminate involving totally different bargaining arrangements. And the second principle was that the burden of proof could be established by using statistics. It sounds incredibly simple, but in fact it was revolutionary because the burden meant if we could establish that gender segregation, it would be enough to pass the burden to the employers for them to have to justify why there's pay discrimination. And again, it's a principle that we use every day. So an interesting side issue on that case was when it was launched, it was predicted that they would win £100 million. The government fought it for 14 years, and they ended up sharing £12 million. So health statistic warning, don't believe everything you put in the papers about how much people are going to get as part of it. You'll see a lot of that in the shop assistant cases that are being put at the moment. So a long struggle for not as much as they should have got, really. Third EU legend is a Mrs. B.S. Leves. I have searched high and low for a picture of Mrs. B.S. Leves, and I have failed miserably. So I'm afraid all I can do is quote you the ruling from the European Court of Justice. This is, for us, a very simple principle, and for me personally, for the work I've been doing, this is the most important case of all. And why is that? Because they challenged this 2-year time limit rule on equal pay. And the European Court of Justice says it was a unique time limit. There were no other matching time limits that affect. And it required the jurisdictions to have an equivalent time limit. Now, some of us actually think this is even that is not in compliance with the ILO convention, because if you've been discriminated for 12 years, why should you only get 2? Why should you only get 6? If you've been discriminated for 12 years, why should you not get 12 years if that's the period of discrimination? It still means that an employer could save money by keeping the discrimination going as long as possible. And that is exactly what is happening in Glasgow, in fact. But it meant that for England, we were able to pursue cases for 6 years prior to the Employment Tribunal claim and 5 years in Scotland. Economically, this made equal pay cases financially viable. It meant that I could afford to leave my firm and start fighting these cases, because there was a chance that I could get I actually get paid. And this is the effect. I'm sorry, these are, I don't know what you can see these numbers. This is, I need my glasses for this one. This is the ACAS statistics. So you remember the ACAS statistics we had from 1976 to 1980. This is 2003, 2004. This is the first year after I left my trade union firm and set up and started issuing cases. And you'll see there's a column that says equal pay cases. And you'll see that East of England had 17 cases. South West had 18 cases. And the two areas where I was working, 1,139 and 920. And although it says the North West, it's because that includes Cumbria, and Cumbria is also part of our area. Next year, North East, 4,655 cases. 6,000 cases nationally in 1 year. That's 3 times more than any year since 1976. I'm getting good at this stage. 12,383 cases, and we've spread to Yorkshire and Humberside. Scotland has now come in with 976 cases. And then they changed the, ACAS changed the way they present the figures, which is really annoying. This is the fourth year, we're up to 25,264 cases. I'd like to note the figure on the right-hand side. That's the total number of cases submitted to the tribunals in that year, 105,177. So the previous statistics, the highest number of cases was 2% of all tribunal cases. We're now up to 25% of all cases. And then, if we can see 2000. Yes, my summit. 2007 to 2008, 53,952 equal pay cases. This is the first time that equal pay became the #1 jurisdiction in the employment tribunals. We went from bottom to top in 5 years. That was only because of Mrs. B.S. Levitz. And I wish I had a picture. Now we need to talk about the trade unions. I'm a trade unionist. I've been a trade unionist. I was a trade unionist from when I was 18. Attacking the trade unions is almost an anathema, something I did not want to do. But I'm afraid they came to hate me. And it started with this guy. This is Stuart Hill. Stuart is a troublemaker. Stuart likes to be a troublemaker. Stuart was the Newpie shop steward for Cleveland County Council. He represented the manual workers before they were subsumed into Unison, and their managers took over running the union. In 1995, the Cleveland County Council decided it would save money by cutting the pay of catering staff. They didn't cut the pay of anybody else, they just cut the pay of catering staff. And you'll not be surprised to know that 98% of catering staff working for the council were women. Well, bizarrely, the person who was responsible for that decision was a Unison shop steward who sat on the personnel committee of Cleveland County Council. That created a problem for Stuart, because Stuart was part of the same union movement. He could not get permission to pursue a case. So Stuart sneaked off, spoke to a GMB rep called Eileen Goodenough, who again won't let me photograph her, so I'm afraid Eileen doesn't get a picture either, but she's a legend too. Eileen came to me, and we started the litigation. Now, the thing about trade union movement is they actually compete amongst themselves. It's not much so, they're always fighting amongst themselves. And GMB and Unison are always trying to poach each other's members. So when Unison heard that GMB was submitting equal pay cases, they decided that they had to do the same thing. And what they did then was they submitted one form. They named all of their members as claimants. They got no permission from any of the claimants to actually submit a claim on their behalf, which is definitely not kosher, but they got away with it. And the long and short of it is that we recovered record amounts of sex discrimination and over £5 million in back pay for the women. But that's not the significance of the story. Significance of the story is after we got that settlement, Stuart lost his job. Part of the settlement was that they would pay back pay, and then they would have a review, and they would implement the changes within 6 months. GMB took Eileen off the case. They put her into a back office job and forced her to retire 2 years later. The officer that replaced Eileen did nothing, literally nothing. So no review, no 6 months. The women stayed on the same terms and conditions as they always had been, getting less money than the men. And then the trade unions on a national level agreed on moratorium. They agreed that they would not pursue equal pay cases for any of their female members in local government, and they wrote it in a national agreement that that was what they were going to do. It was supposed to last 1 year. Year 2 came by, moratorium stayed. Year 3 came by, moratorium stayed. So you have this bizarre position that the trade unions agreed nationally that they would not pursue a discrimination issue on behalf of something like 450,000 members in a local government. That's why I left and why I set up my firm. I'm afraid the women don't want me to put up their photographs. This is really annoying, but there are these two more legends, Joan and Peter Hamilton. And Joan is the real legend, Peter's the victim. Joan was a cook in South Tyneside Council. So we had started the cases in Middlesbrough, and the women in Middlesbrough obviously told their friends and colleagues in the trade union movement what was happening in Middlesbrough. Joan said, well, we're in exactly the same position, we do exactly the same jobs as these women, why don't we have got equal pay case? And Peter was the branch secretary for South Tyneside Council, for the GMB. And they were a GMB family because not only did was Joan a shop steward, Peter was the branch secretary, their daughter worked in GMB head office. So Peter asked the union if they would pursue equal pay cases on behalf of their members in South Tyneside, like their colleagues in Middlesbrough. The union said no. So Joan came to me, and I submitted a case on behalf of Joan. Result was, literally the next day, they sacked the daughter, they suspended Peter, and Peter lost his job. Joan stood up. Joan recruited hundreds of her colleagues to pursue cases. The GMB then submitted cases because they could see this was a bit of a problem. And when we had the case listed for hearing as the employer's defence, 2 months before the hearing was due to take place, the GMB pulled the plug on the cases. They settled the cases on behalf of their members. We had to go ahead with Joan to the tribunal, which we won. If we had lost that case, that would have been the end of my career. This was the first of the major GMF hearings. And it's because of Joan's tenacity that we were able to pursue that case. We got 5 times more for our clients than the GMB got for theirs only 2 months beforehand. Paul Savage. You're going to get a theme going here. Paul Savage was a full-time officer for the GMB. The last thing I did before I left, I'm really sorry to Paul for doing it to him, but the last thing I did before I left was to persuade Paul to put in equal pay cases on behalf of his members in Cumbria. Guess what happened to Paul? He lost his job, he came to work for me, during the next 3 years, we're doing all these cases in the North East. As you can see from the stats, nobody else is pursuing cases. What's happening is the trade union stewards are asking their unions to pursue cases, and they're refusing. If we were not in the area, they pursued no cases. We came down to Birmingham. Paul was given the job of running Birmingham. Literally 4 weeks after we put our first case in Birmingham, the trade unions went to the employers, got them to sign a deal for their members to receive a settlement, a sum. We didn't accept the deal. We fought the case. We won the case, and our people got 5 times more than the trade unions did. But by that time, the trade unions had slagged us off so much that we only had a couple of hundred members who actually ever received the first award, because the vast majority of them had received their money. But the employers then did exactly what I said had happened in Sunderland. So they put in a new pay structure, and guess what? New pay structure produces exactly the same results as the old pay structure. The thing about Birmingham was it was unbelievably generous. It was 2 facts that about Birmingham. One is that the highest paid man in every job was the shop steward. And the second was that they were paying bin men more than solicitors in the council. They were paying bin men over £40,000 for doing a job where the basic rate is £12,000. So we sued Birmingham again. This time the trade unions had already signed up. So the people couldn't go back to their trade unions because they'd signed up on the new deal. So we ended up with over 5,000 women in Birmingham pursuing that case. By this time, Birmingham had got really sick of me, and they literally came to me with an offer that I couldn't refuse for my members. So I left Birmingham. My clients got paid out in 2012, 2013. Birmingham is still fighting everybody else. That litigation is still ongoing. Paul was the person who organised, Paul and a colleague called Paul Durham were the legends in Birmingham. How we? I knew this was going to happen. Okay, you'll have to ask me about GPG because he gets me angry and I can't do it in 5 minutes. And equal pay day. That's another one that drives me nuts. Legend, Carrie Gracie. Carrie Gracie. Why is Carrie Gracie a legend? Why is it obvious? The first thing is that she publicly fought a battle with a significant employer. This is one of the, although I've been able to put up some of the females involved in this, there hasn't been a person who personified the fight for equal pay. So in really 50 years, Carrie Gracie is the first person, there's a public face that you can think of. If you think about equal pay, first face you think about should be Carrie Gracie. In America, they have a woman called Lily Ledbetter, who went to the Supreme Court, and she got equal pay law changed over there, and she's a celebrity in America. The second thing is that she recovered £360,000 in back pay as part of her claim. She donated every single penny to fighting equal pay for other women. Now, I've been generous to the school, but I have not been that generous. And I am not going to be that generous. And I will explain it if you want me to. But GPG is not a measure of unequal pay. And Carrie's case proves fundamentally GPG does not mean... BBC has a GPG of less than 10%, which isn't bad, but it's actually less than the national average. Carrie's pay gap was 60%. There's also a Southampton connection to this as well, because her comparator was a Southampton alumni. Naughty man, Mr. Sopel. So you have a woman. So if that's all the information that you had was your GPG stat, you think, well, I'm on 150k. The GPG is 9%. So I'm losing £15,000 a year, am I? No, you're not. No, she wasn't. She was losing over 100 grand a year doing an equivalent job. GPG hides equal pay. There we go. Who said that? Glasgow. I can't finish without talking about the women of Glasgow. I have two heroes, one of which I think you'll be surprised about. This is this lady in the corner, the bottom right angle. That is Frances Stojkovic. She is a genius. She is a home carer, and she has used this guy to pursue her case. She set up a Facebook group. It has transformed the litigation in Glasgow. It has transformed the lives of these women. for the very first time, see what would happen as I was doing litigation as a solicitor, doing my normal obligations. I have an obligation to write to my clients once every 6 months, telling them what's going on. If I manage to do that, I won't have the SRA on my back. And that's what we used to do. We used to send the annual reports every 3 months. Actually, we did it every 3 months. We would send the reports. Usually, however hard we tried, it would probably be unintelligible to most of our clients. Frances Stojkovic and her Facebook group means that I am able to communicate with my clients on a daily basis. It has also meant that she's been able to gather over 2,000 of her colleagues, all focused on the cause. And you'll have to ask me questions about Glasgow. All I can say is that, final stories, is that because of that, the women of Glasgow have been able to stand up for themselves. The amazing thing about what they did is to see their own self-worth increased as a result of what they have been doing in Glasgow. It's an amazing thing, and it's down to Facebook, not me. That is as far as I'm allowed to say, so I will now hopefully have the better part of the day and we'll have some questions.
So thank you very much, Stefan, for this very interesting and inspiring lecture. I think you have reminded us of the many popular assumptions and sometimes misconceptions about equal pay and the gender pay gap. For instance, that actually the UK had already obligations towards women equal pay from the Treaty of Versailles well before the Equal Pay Act was passed. You have reminded us about the pension pay gap, which indeed gets forgotten very often. You have reminded us also about the differences between equal pay and the gender pay gap, which are different concepts, among many other really interesting highlights. And I'm sure that this has prompted many questions and thoughts. We have a bit of time for some questions from the audience. So I'm inviting questions now. If anyone would like to ask anything to Stefan, this is your opportunity.
I have a question not entirely related to equal pay, but about the Centre for Women Equality in the Law. Have you been in contact with, or are you planning on being in contact with the charity Pregnant Then Screwed?
I haven't been in contact specifically, although we're regular Twitter correspondents, and I know the people who are involved there. Their campaign illustrates the problems with the law. So everybody knows that dismissal on the grounds of pregnancy is unlawful. But 54,000 women every single year report that they lose their job as a result of their pregnancy. And it has to be said, well, what is failing in the law that the women are not able, A, that happens, and B, they don't have proper redress? I would have thought it was a significant subject for the Centre to investigate. I mean, the Centre's not limited to equal pay, it's not just because it's my area of obsession. That is another issue that really, why is it that the ECHR have not, they send out reports, but what are they actually doing to change the position? So, and the second thing is, we haven't discussed this, is that what I want the Centre to be able to do is to make those links. So there's lots of work being done with lots of different centres, academic and practitioner-wise, which just aren't being joined up, and that's one of them. So if we can get that to happen, brilliant.
And slightly linked to that, I wondered whether you thought there was anything that could be done about unconscious bias in the workplace. Unconscious
bias?
Yeah.
It's unconscious, so... I know in terms of unconscious bias, I think that there are many things that you have to make it conscious. If there's one good thing about the GPG stats is it makes something conscious. It has nothing to do with equal pay, but it does make female progression on the table and transparent. And it means that some employers will address their minds to the issue because there are some employers who are simply shocked by their own statistics. The law is absolutely terrible on this. I mean, the law is shocking. But they are now having to focus on those issues because they've been made conscious of it. I don't think it's anything like good enough, but it's a step in the right direction. I think there should be direct obligations to take action, to investigate, make it transparent, and act. And none of those are currently legal obligations.
Thank you.
If I can just quickly add to that, the Centre is very interested in working with all kinds of stakeholders, including charities. Obviously, the Centre has just been launched, so we haven't had materially the time to engage with all the stakeholders we would like to, but we are looking to do research on any issue that links with gender discrimination, not only equal pay, of course equal pay too, and to engage with all kinds of stakeholders.
Hi, you just were ending there about the use of Facebook to recruit lots and lots of colleagues to support her fight. I was just wondering, do you view the web, social media as an asset to the fight for women's equality, both in pay and just in general in society?
With all the caveats of the downside of social media,
Yeah.
I would still say yes.
So overall, yes.
Overall, it can have an amazing joining up of people that don't know that they've got the same issue. So Me Too, for example, Me Too happens because people are taken away from being isolated, that they can join up with others. I mean, obviously, it's terrible nightmares. My experience is that there's a massive difference between Twitter and Facebook. My clients are not on Twitter. Well, very few of them on Twitter. But they all, almost universally, they're on Facebook. And it's not about recruiting people. It's about creating solidarity amongst the group that's really important. And the ability to communicate with each other, so the ability to ask simple questions amongst themselves and to me. As I said, it creates a community and a solidarity that simply didn't exist before. Well, you're all a letdown, come on.
Obviously, like a lot of people, when you talk about the gender pay gap, talk about things like maternity pay and maternity leave and even time off for children. How much of that actually accounts for the gap in pay?
Okay, well, let's start with the first thing. The gender pay gap is not a measure of equal pay, it's a measure of progression. So it's a really bad tool for measuring those things. Even the ONS accepts that there is a motherhood penalty. But it's not the only penalty. If you look at the stats, there are three major factors: part-time work, age, and motherhood. And you can separate out all of those. The ONS study itself says that they can only explain 36% of the difference due to non-discriminatory factors. So you will hear a lot of people like the IEA say the gender pay gap is a myth completely. That's absolute nonsense. There's nothing to support that position. Even the American studies, where the comparisons are really dodgy, they are unable to completely explain the pay gap for non-discrimination. But in my view, the gender pay gap is a better measure of female progression than it is a measure of pay. The problem is that there is no real proper measure of unequal. Until we have proper pay transparency, like the BBC were forced to have, and only for a small group, will these pockets of discrimination be exposed. But in terms of your question, no doubt that's absolutely right that they are penalties and they can be proven, but they're not the only ones.
Just a quick question. Did any of your cases also address the issue of multiple discrimination? I mean, being discriminated against not because you are a woman, but you are non-British or sexual orientation as well?
No. It's there isn't the stats, and it's not necessary for our cases, to be honest. I mean, it is a significant issue that the coalition government essentially abolished the possibility of pursuing intersectional discrimination. The difficulty is that we haven't got a case that highlights the issue. We would need, I think we sort of need a Carrie Gracie type arrangement where we've got an individual who can prove that it's actually double discrimination. The reality is Glasgow is 99% white British, or Irish as well. There isn't that. Actually, there was an issue is when I tried to do it in London, it was a major problem because the vast majority of the women doing this job were not British, and they were disparate. There was no community involvement. So actually getting a group to pursue the case was almost impossible because of that, the makeup of that particular group.
Hi, I wanted to ask, how do you encourage young people to fight for gender equality or reducing the gender pay gap, stuff like that?
Good question. Let me think about that one. I'm a bit old for advising young people. I think the answer is community. The worst thing about discrimination is being isolated and not being able to speak to other people or get support from other people. And it is enormously difficult. I mean, before I was doing equal pay cases, and I did do sex discrimination cases, I can't think of a single case of sexual harassment or sex discrimination where the woman didn't lose her job or didn't have to at least move. It is enormously expensive not in money, but in social capital in pursuing an equal pay case. To do that alone is phenomenally difficult. So community and communication are the only two things that are going to be able to enable you to do that.
All right, thanks.
We have time for one last question.
I was reflecting, I'm not an expert, but I'm really reflecting on there must be a source of this discrimination, inequality. Sometimes we think that it could be in the household, so there is definitely that source. So since 1954 or 1968, we have been discussing this. There are legislations in place. Yet, why is it still, why are we still really debating about this?
Because women are undervalued. It's as almost pure, as simple as there are other aspects. I mean, one of the things in relation to the men, and my colleague Robin Allen QC argues that it's a zero-sum game, and the problem is that the size of the pie is fixed. And therefore, if you're going to redistribute, then somebody's going to be losers. The trade union movement in particular seeks to maintain the status quo as a baseline. It wants to improve the status quo, but it won't move from the status quo. Well, that means that getting benefits for women is an add-on. It can only be a plus, and it's actually a massive risk for their male members if they simply have to redistribute the size of the pie. But it does come down to people having perceptions. I mean, I remember the Labour leader of York City Council publicly saying when we started to sue them, this was absolutely ridiculous, he said. Nobody can possibly believe that a refuse driver is equal to a home carer. They had been on the same grade by his job evaluation scheme for over 25 years. when he made that statement. It was a knee-jerk belief in value between the two, and we fight that all the time. The biggest problem in these cases is not getting the back pay. The biggest problem is getting the women re-evaluated and properly valued as part of the pay structure, and that's still a problem.
Well, thank you very much for all your very interesting questions. Thank you, Stefan, again for your insightful answers. Thank you once again for coming down today and for all your support to the law school, to the center, and especially also for being a role model with your work to fight gender inequalities with all these equal pay cases. And we hope Stefan will be back soon to share his expertise with us, to contribute to the center. In the meantime, we are organizing many activities, seminar series, including a seminar on the 5th of December on the impact of Brexit potentially on gender equality, so you're all invited to attend. Check our website for updates, and once again, thank you for coming, and good night.